Imagine Disney's worst nightmare: losing Mickey Mouse. For nearly a century, Disney has fought tooth and nail to keep their most valuable characters locked away. But copyright law doesn't last forever. In this video, we're exploring what actually happens when Disney's iron grip on a character expires, the legal battles they've waged to prevent it, and the shocking ways creators are now using classic Disney characters in ways the company never imagined. The story is wilder than you think. The Winnie the Pooh horror show, a wake-up call. In 2022, something unprecedented happened. A slasher horror film called Winnie the Pooh. Blood and Honey hit theaters. Yes, you read that right. Pooh Bear as a murderous monster hunting down humans. The film was terrible by most accounts, but it made headlines worldwide for one reason. It was completely legal. How did this happen? In January 2022, A.A. Milne's original 1926 Winnie the Pooh book entered the public domain. This meant anyone could legally use the character as depicted in that original work. The filmmakers behind Blood and Honey jumped on the opportunity immediately, creating a twisted horror version that Disney could do absolutely nothing to stop. But here's the crucial detail most people miss. They couldn't use Disney's Pooh. The version we all grew up with, the chubby, friendly bear in a red shirt, is still 100% owned by Disney. That specific character design, that red shirt, the way he talks, his mannerisms, all protected by trademark. The horror film used a deliberately different design, a more realistic, disturbing version based on Milne's original text and illustrations, not Disney's interpretation. This is the key distinction when characters enter public domain. You can use the original version, but not later adaptations. Think of it like this. The 1926 Pooh is a bare-bones character sketch. Disney spent decades adding layers. Personality, visual design, voice, backstory. Those layers remain Disney's property. The public domain only gives you access to that original sketch. The Blood and Honey situation sent shockwaves through Disney. If someone could turn beloved Pooh into a horror villain legally, what could they do with other characters? More importantly, what happens when Mickey Mouse himself enters public domain? Why Mickey Mouse is different. Mickey Mouse isn't just a character to Disney. He's the foundation of a multi-billion-dollar empire. He's the company logo. He appears on merchandise worth billions annually. He represents Disney's brand identity in ways no other character does. Losing exclusive control over Mickey would be catastrophic for Disney's business model. But here's the problem Disney faces. Mickey Mouse debuted in 1928's Steamboat Willie. Under original copyright law, that should have entered public domain in 1984, 56 years after creation. Disney couldn't let that happen, so they lobbied Congress. Hard. In 1976, Disney pushed for copyright extension, moving the deadline to 75 years. As the new deadline approached in 2003, Disney lobbied again, resulting in the Copyright Term Extension Act of 1998. Cynically nicknamed the Mickey Mouse Protection Act because everyone knew exactly why it existed. This law extended copyright to 95 years for corporate works. But even Disney can't change copyright law forever. On January 1, 2024, Steamboat Willie finally entered public domain. Steamboat Willie enters the public domain. What changed? When Steamboat Willie hit public domain in 2024, the internet exploded with Mickey Mouse parodies, horror versions, and experimental art projects. Disney, for the first time ever, couldn't stop them. But, and this is crucial, they can only use the Steamboat Willie version of Mickey. That 1928 design is distinctly different from modern Mickey. Steamboat Willie Mickey has smaller eyes, a rat-like face, no gloves, skinnier limbs, and a completely different personality. He's mischievous, sometimes mean-spirited, and lacks the friendly warmth of later versions. Modern Mickey, the one with big eyes, white gloves, friendly smile, and gentle personality, is still completely protected. Disney's modern character design, developed over decades, remains their exclusive property. So does the name Mickey Mouse as a trademark for merchandise and entertainment services. This creates a bizarre legal landscape. You can make a horror film featuring the 1928 Mickey design, but you have to be extremely careful. Add white gloves? That's trademark infringement. Gloves weren't added until 1929. Make him too friendly? You're using Disney's later character development. Call your product official Mickey Mouse merchandise. Trademark violation. Disney's lawyers are watching, ready to pounce on anyone who crosses the line. Several indie horror games and films have already been announced using Steamboat Willie Mickey. Disney has issued statements emphasizing their continued protection of modern Mickey and promising to defend our rights aggressively. The message is clear. Tread carefully. The Copyright Extension Wars. How Disney Changed American Law. Disney's influence on copyright law is staggering and troubling. Before Disney's lobbying, copyright terms were reasonable, creators got protection for a limited time, then works entered public domain for society's benefit. This balance allowed new creators to build on cultural foundations while still protecting original creators. Disney fundamentally altered this balance. The 1998 Copyright Term Extension Act didn't just protect Mickey. It froze thousands of works from entering public domain for an additional 20 years. Characters from the 1920s to 1940s that should have become public remained locked away because Disney needed to protect one mouse. Critics argued this violated copyright's original purpose, encouraging creation by eventually allowing works to enrich the public domain. Disney's lobbying essentially privatized culture, keeping beloved characters locked behind corporate walls indefinitely. The law's nickname, Mickey Mouse Protection Act, wasn't affectionate. It was accusatory. Disney had bent American law to serve corporate interests over public good. Legal scholars filed lawsuits arguing the extension violated the Constitution's requirement that copyright be for limited times. The Supreme Court upheld the law in 2003, but the 5-4 decision was controversial. What's particularly galling, Disney built its empire by adapting public domain stories. All public domain fairy tales Disney transformed into billion-dollar properties. Then they turned around and fought to prevent others from doing the same with their characters. The hypocrisy is breathtaking. Real cases. When Disney strikes, Disney's legal department is legendary for its aggression. They've sued the Air Pirates, underground comic creators who made adult-themed parodies of Mickey in the 1970s. Disney won, establishing precedent that parody has limits when it comes to their characters. deadmau5, the electronic music producer whose Mousehead logo Disney claimed infringed Mickey's trademark. Despite significant visual differences, Disney forced a settlement. Should Disney maintain eternal control over characters like Mickey Mouse, or should they enter public domain after reasonable time? Drop your thoughts in the comments. If you found this deep dive into Disney's copyright battles fascinating, hit that like button and subscribe for more videos exploring the intersection of law, business, and pop culture. Thanks for watching, and remember, even Mickey Mouse can't escape time forever. See you next time.